I cannot hear you.
Hello?
Oh, yes, I can hear you now.
Yeah, sorry, I was talking on mute.
Miss Pompey, you can put on mute. Okay, yeah, you got it.
Does anyone know if we were able to obtain a Korean interpreter for position number 1, Mr. An?
Miss
The
Butter, I did not get a calendar. I don't know why. Can you forward me one?
Hello, I'm the interpreter here, Sarah Choi.
Okay, thank you.
Miss Bridgewater, you're muted.
Oh, I'm unmuted
Yes, Judge,
now.
I'll send you a calendar.
Yeah, I don't know what happened. If I deleted it, but it's,
Okay, no problem. I'll send you one.
thank you.
Okay.
I cannot hear you. Sorry, I'm not able to hear you.
Just a minute. I'm trying to
Okay.
send the judge a calendar. No problem.
Okay, all right.
Hopefully she'll get it in just a moment.
She should have it.
Oh, and I just noticed we're having Williams instead of Missy.
Correct. I sent it to her anyway. She should have it.
Okay, very good. So she should be back on very shortly. And that could be the reason why she didn't get it, because it's a different name on it. Hmm.
sent it to her other email.
All right, we're gonna go ahead and begin. I do not have a calendar today, so everyone bear with me. It's gonna take me some time. Ms. Bridgewater has agreed to help me so that we are not sitting here and delaying the calendar. This is the state expedited accusations calendar. This calendar is for those individuals who've been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at these proceedings. All participants, these proceedings are being broadcast over the internet as a live stream. They are also being recorded. That means any member of the public can log on and watch these proceedings. When I asked you if you understand your rights, these are the rights to which I am referring. All right, who do we have at courtroom 2?
Judge, we're gonna start with position number 4, Ms. Cooper, and after Ms. Cooper, we can do the breakout session with courtroom number 2 and PD Wells and whoever the interpreter is. Thank you.
Okay, so do we want to do the breakout now or we need to wait? Can the breakout go
We need to
on
wait
while?
We can do the breakout now, Judge.
No, that's not what we said. We're gonna do position number 4 first and then the breakout session.
Oh, all right. We're off to a
Thank
great start this afternoon. All right, give me one moment. I'm hoping
And the
that.
break. Oh,
Hold-
I'm sorry, Judge. I was just saying that the breakout client is mine, Mr.
Okay. Okay, now the calendar comes through. Okay, so
Okay.
we're in good shape. Give me one moment to pull it up.
Well, we can do the breakout session in the courtroom too. I thought this was the breakout session was Ms. Wells' client.
Since it's Miss St. Flex, let's go ahead and do that breakout if we can. And we have, I'm sorry, position what? Now that I finally have a calendar, who is?
4, courtroom number 3.
All right, wonderful. Thank you so much. I appreciate that. All right, let's see. All right, Ms. Cooper, your case is 23 CR 002557Y. In this case, you're charged with simple battery family violence. Do you understand your rights today?
Yes, ma'am.
All right. Well, let me explain. You have a right to remain silent and you have a right to an attorney. Do you understand those rights?
Yes, ma'am.
All right. Mr. Hart, can I have her history, please?
Second arrest, 2020 ag assault on robbery, possession of a knife or a firearm during the commission. That was dismissed.
Thank you. And it's going to take me a second to toggle back and forth. Whose case is this for the state of Detroit, Ms. Bickerstaff?
Yes, Your Honor. How are you today?
Good afternoon. Please proceed.
Yes, so this offense, this happened on yesterday at 1935 Allison Court Southwest. And this is where officers arrive in response to a dispute between the defendant and Mr. Victor Sanchez, the defendant's boyfriend. The defendant advised that Mr. Sanchez came over to receive some toiletries, and while there an argument broke out, the defendant told officers that Mr. Sanchez pushed her, and then in response to that, Mr. Sanchez punched her. The officer did note in the warrant that the defendant was under the influence of alcohol. Mr. Sanchez, however, told the officers that the defendant woke up and the defendant woke Mr. Sanchez up wanting to discuss a relationship he had with another woman. And so Mr. Sanchez told officers that the defendant then punched him in the face. The officer noted that he did see blood on Mr. Sanchez's lip, Your Honor. For these reasons, the state's recommendation is a $3,000 surety bond, 1-day anger awareness, no further contact with Mr. Sanchez, and no alcohol, drugs, or weapons while out on bond. And I would like to sound for Mr. Sanchez if he's on the Zoom call.
All right, Mrs. Sanchez, are you present?
I had Miss
No,
Wills.
Ms. Cooper, don't say anything, okay? All right, Ms. Wills, please proceed.
Thank you, Judge. My client is 22 years old, and she is struggling with housing at this time, and I have made a request for a social worker to go and meet with her about that. Ms. Cooper does deny the allegations as alleged, as she is actually the person who called law enforcement to the scene, and states that both she and Mr. Sanchez waited separately and independently waited for law enforcement to arrive. I spoke and I had the opportunity to speak with Mr. Sanchez earlier today. He indicated that he wants to continue to have contact with Ms. Cooper, that he is not fearful of her. And speaking with my client, she would also like to maintain contact, but stated she did not believe it would be in their best interest to live together. So I would ask for no further violent contact between the two of them. And then I would also ask for a $3,000 surety or signature on bond. And if your honor is not so inclined, I would ask for the lowest bond amount possible. My client is, excuse me, from Georgia. Oh, I'm sorry, she's been in Georgia for 16 years. She does have family that resides here. And so for those reasons, I would ask a signature for a signature bond.
All right, at this time, defendant will receive a $1,500 surety bond. She's to have no contact with Mr. Sanchez at this time. Is the Allison Court address alleged to be the defendant's address or where the victim resides? I need to clarify that. Stay away, Ms. Bickerstaff or Ms. Wills.
I believe that it's, well, let me not say what I believe. Is that, Ms. Wills, do you know whose address that is?
I'm not sure. When I spoke with Ms. Cooper, she stated that she did not have stable housing, so
Okay.
I'm not sure.
The police report to me read that it was her address, but I would like to, because of that, stay away at the incident location.
All right, if that's Ms. Cooper's address and the defendant does not reside there, she can return to that address. Otherwise, she must stay away. She can return with law enforcement one time to make that determination. Additionally, she's to have no drugs, alcohol, or weapons as a condition. Is there anything further?
Judge, let me just put on the record that the reset date for the SAP calendar is May the 9th.
Thank you. And this case will be so reset to the May the 9th SAP calendar should Ms. Cooper not make bond before then. All right. Anything further? Best of luck to you, Ms. Cooper. Who do we have next?
Position number 3, please.
All right. All right. Are you Ms. Chapman?
Yes, ma'am, I am.
All right, Ms. Chapman, your case number is 23CR002556E. In this case, you're charged with simple battery family violence and battery family violence, each with the offense date of April the 25th. Do you understand your rights today?
Yes, ma'am. However, I've only been acknowledged of one charge.
Okay. Well, you'll hear more about that in this proceeding, okay? All right, as this is her first arrest, we'll go straight to you, Ms. Bickerstaff.
Yes, Your Honor. So this incident occurred yesterday around noon at 5310 Arbor Gates Drive. And this is where officers arrived in response to a dispute between the defendant and Mr. Joseph Bradley, the defendant's boyfriend. And the argument started over the defendant's employment status, then escalated to a physical altercation where Mr. Bradley began recording the defendant acting irate. The defendant charged Mr. Bradley in an effort to get him to stop recording her, which resulted in both Mr. Bradley and the defendant falling to the floor. Mr. Bradley sustained a dislocated finger because of this altercation, Your Honor. The altercation was recorded on Mr. Bradley's phone. And furthermore, the defendant told officers that they were they were having a dispute over her employment status, but she said that the defendant stated that Mr. Bradley tackled her and held her down after he had been screaming at her, Your Honor. Our victim advocate was able to speak to Mr. Bradley, where he did state that he has suffered an injury to his hand and he had to go to the hospital and he has a splint on his finger. He also told us that he doesn't want any further contact with the defendant and he would like a stay away order at that address. And so for these reasons, The state's recommendation is a $5,000 surety bond, $3,000 for battery, $2,000 for the simple battery, a 1-day anger awareness course, no further contact with Mr. Bradley, and to stay away from the 5310 Auburn Gates Drive address, as well as no alcohol, drugs, or weapons while out on bond.
All right, I'm sounding for Mr. Bradley at this time. If you're present on the Zoom conference. All right, Ms. McLeod, please proceed.
Yes, Your Honor. Good afternoon. My client is 26 years old. She is gainfully employed, Your Honor. She does have some college education. She tells me that she will be starting college for her nursing career May 8th. She also tells me that she was living and working in Nashville, Tennessee. She met the alleged victim online and they began a relationship and they talked, started visiting each other. And then he invited her to move to Atlanta to live with him. She secured employment and she was actually living with the defendant. She was having a little issue with her job, so she didn't want to go in because she took a couple of days off because she decided that she probably should look for other employment. And she had explained that to the alleged victim. He came at her, about why she was going to work. And she tried to explain to him what was going on at work. He became very irate at her. And then she said, okay, I'm going to leave. She tried to get her stuff. He kept following her around and trying to record her. And she told him not to record her. And she went towards him. And that was when he actually took her to the floor, Your Honor. He flipped her down to the floor and she was injured. She has marks and scratches and other injuries and had to be treated for those injuries, Your Honor. My client does not have any kind of criminal record. I would ask the court to give her signature bond so she can get out of jail. Also, her cell phone and all of her belongings are at this location and her car. I would ask the court to give her a one-time police escort back to this location so she can retrieve her belongings, especially her cell phone, her clothing, and her vehicle. She really doesn't want any further contact with the alleged victim either, Your Honor. Nothing further.
Mr. Bradley, I see you're present on this Zoom conference. If you'd like to make a statement, this is your opportunity to do so. You're not required to. Do you wish to make a statement?
Yes, Your Honor.
Okay. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
I do.
All right. Are you driving?
No, Your Honor, I'm parked.
Okay. If you were driving, okay. I just noticed a seatbelt. I was wondering if you cannot operate the car and give us a statement. I want to explain that this is a bond hearing today. I will not be sentencing anyone. This is not probable cause either. So the facts are not as important as they might be at a later date. What the court is most concerned with is whether you wish to have contact with her, and I'll allow you to make a limited statement. So what would you like to tell me at this time, Mr. Bradley?
Yes, Your Honor. Thank you for giving me this time. First thing is, I agree that she could and should get a police escort back to get her belongings. I already packed up her belongings and had them at the door and ready for her. I just didn't feel safe with her being there by herself. That's the reason why I called the police in the first place. And I already know her cell phone, her car is there. I have no problem with that. A lot of the stuff that she said wasn't true, and the police saw the video, and that's why they made their arrest and their determined, because they saw the videos of what actually happened. And she has been doing this even with her job, fabricating certain things. And I was taking her side. I even helped try to find a new job, and I worked on her resume for her. I got her a computer for her. I did not become irate at all. It was actually the other way around, and I have it on video. I was calm the entire time, and she got irate. I was actually on my way out the door to leave. I had the garbage bag in my hand, and she actually started initiating contact. And so I pulled the video out as protection for me. I was not following her around or anything like that. The police saw the videos as well. They saw me retreating back and her attacking me, and she pulled me to the ground. As you can see, I went to the hospital yesterday. The police told me to go to the hospital, and she actually injured my hand. So any marks that she has on her, she indicated it herself. I didn't do anything. They saw the video. They saw I didn't do no harm to her or anything like that. And she has been doing this even to me, manipulating me and saying that people at her job are not treating her well. But she speaks to people very, very like maliciously. So I had her back on that, but I don't do violence. I don't like that. I have 3 sisters, and I wish to have no contact with her at all. Already, blocked her on certain on all the social media stuff. And I would love if the police escort came by because I don't feel safe being around her. So that's why I say. I would just like to know when she would get out so I can make sure that I'm home, because I usually do things around 6 p.m. or something like that.
Okay.
I just want to make sure that I am home.
Yeah, the court will not be able to get and tell you a specific time and deal with scheduling, but I do appreciate you coming to court making a statement. I know both state and defense want to make limited statements. Ms. Bickerstaff, any limited statement? Very limited.
Nothing from the state, Your Honor.
Ms. McLeod?
Nothing from the defense, Your Honor. And Ms. Chapman, don't say anything. This is your bond hearing. You can call me if there's anything that you don't understand.
All right, defendant will receive a $2,000 surety bond, $1,000 on each count. She's to have absolutely no contact with Mr. Bradley, whether via text, phone, social media, or otherwise. She's to stay away from the incident location. She can return one time with a member of law enforcement to get any of her possessions. Additionally, she's to have no drugs, alcohol, or weapons as a condition. Is there anything further?
Nothing further, Your Honor, for the defense.
All right, best of luck to you both. That concludes this hearing.
Have a seat on the first one. Position 13 is next, Judge.
All right, thank you.
Come on, Ms. Rutledge.
All right, good afternoon, Ms. Rutledge. I'm going to read you your case number shortly. All right, your case number is 23 CR 002565J. You're charged with loitering and prowling with the offense date of April the 24th. Do you understand your rights?
Yes.
All right, let me look. Okay, Mr. Howard, will you put the history onto the record?
4th arrest, 2018 possession of drug-related objects, 2017 driving without a valid license, and an 06 simple battery. This was SOB jail recommendation.
Okay, thank you. Mr. Young?
Yes, Your Honor. This incident happened on April 24th, 2023 at 3215 Cushman Circle, Southwest in Atlanta. Law enforcement responded to this location in reference to a prowler report. The accused, along with a co-defendant, which is position 12, were seen by the victim, Samaya Daniels, through her doorbell camera. He was checking the door, trying to enter the apartment and looking under the welcome mat. The law enforcement officer made contact with the subjects outside matching the description. They claimed to be there visiting family members at a particular address. However, when officers followed up to validate their story, they learned that they are not their visiting family. The individuals at that address provided by the accused, they didn't know the accused or the family members, so they were just there. So the state's recommendation is a $3,000 surety bond, stay away from the incident location, no further contact with Ms. Daniels, and no alcohol, drugs, or weapon. And that's it for the state.
Thank you. All right, I see Ms. Daniels is present. Ms. Daniels, do you wish to make a brief statement? Again, this is not a probable cause or any type of trial, but I'll hear a very limited statement from you if you'd like to make one.
Yes, I just
wait, before you speak, we need to see you. You need to be able to turn
okay,
on.
hold on, give me a second. Okay.
And I have to place you under oath. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes.
All right, very briefly, you can make a statement. I think I'm aware of what happened here, but go ahead.
I just was trying to make the statement of them staying away, not being able to come near my property anymore, because I really feel unsafe because it's happened multiple times. But I just want them to make sure to just stay away from my property and not to, try to break in or go whatever they're looking for. It's not there.
All right, I understand, Ms. Daniels. Thank you for coming to court and making that statement today. I appreciate it. All right, Ms. McLeod?
Yes, Your Honor. My client is 39 years old. She is a native of Atlanta. She tells me that she was visiting some relatives at the location. She does not know the complaining witness, and she denies that she was engaged in any kind of illegal activity, Your Honor. It was not this is an apartment complex we're talking about. It's not like it was a house and there are other people living nearby. And she denies that there was anything in her behavior which would amount to loitering and prowling. My client tells me that she's currently pregnant, Your Honor. She is employed. I would ask the court to give her a signature bond so that she can get out of jail, given the nature of the allegations, Your Honor. I think that a signature bond would be in order. Nothing further, Your Honor.
All right.
May I speak?
Ms. Daniels, you've already spoken, but what would you like to say?
I was just saying, it's on video camera that she
Yes,
was.
okay. Okay, yes. All right, we've got the facts of the case. Thank you. I just don't want you to this is not a trial. You'll have your opportunity to speak if the defendant moves through this process, okay? Thank you. All right, at this time, defendant will receive a $6,000 signature bond through the jail. She's to have absolutely no contact with Ms. Daniels, and she must stay at least 100 yards away from the incident location. Additionally, she's to have no alcohol, drugs, or weapons as a condition of that bond. Is there anything further?
Nothing further, Your Honor. And that concludes my business before the court today. May I be excused?
Yes, you may. Take care, Ms. McLeod. Have a good afternoon.
Thank you, Your Honor.
All right, best of luck to you, Ms. Rutledge. That concludes your hearing at this time. Who do we have next?
Position 14, Judge.
All right. All right, good afternoon, Ms. Simmons. Your case is 23 CR 002566D. You're charged with criminal trespass with the offense date of February the 24th. You understand your rights?
Your Honor, I'm requesting a breakout room for Ms. Simmons for MH.
Okay, so can we go to another position then? I'd like to do the breakouts last if we can. Is there another position we can go to?
We can go to courtroom number 2 next, Judge.
All right, who do we have at courtroom 2?
Position 1, Mr. An. That's the interpreter case.
Okay, that's fine. Madam Interpreter, can you please for the record? Are you able to turn on your camera? If you can't, we understand.
I've got it on somehow or other. I'm not able to. It doesn't work. I don't know.
Okay, that's okay. Please state your name for the record.
Sarah Choi, S-A-R-A-H. Last name C-H-O-E.
All right, Ms. Choi, please raise your right hand.
Okay.
Do you swear and affirm that today you will make an accurate translation from English to, is it Korean?
Yes.
From English to Korean, Korean to English to the best of your skills, knowledge, and ability as accurately as possible?
I do.
Thank you. You can put your hand down if it's raised.
Okay.
All right, and everyone, please give as much time as we can to allow for interpretation of this case. Good afternoon, Mr. An. Your case is 23 CR 002554G.
예, Mr. An, 안녕하십니까?
예, 안녕하세요.
Mr. An의 케이스 번호가 23DR 0025542입니다.
In this case, you're charged with battery family violence.
지금 이 케이스가 가정 폭력으로 지금 혐의를 받으셨습니다.
With the offense date of April the 25th.
발생한 날이 4월 25일이었고요.
You have an absolute right to remain silent.
법적 권리로 침묵할 권리를 가지고 계십니다.
Anything you say can and will be used against you.
무슨 증언을 하시든 콜트에서 여기 법정에서 이렇게 나쁘게도 그거를 사용할 수가 있습니다.
You have a right to an attorney as well.
예, 그리고 변호사를 선임할 권리가 있고요.
And this proceeding is being broadcast over the internet.
예, 지금 이거 인터넷을 통해서 지금 이게 진행되고 있습니다.
It's also being recorded.
그리고 지금 녹음하고 있는 상태입니다.
That means any member of the public can log on and watch this.
그 뜻은 어떤 누구든지 밖에 사람들이 인터넷으로 들어와서 이걸 볼 수가 있어요.
Do you understand your rights and how I'm conducting the hearing today?
예, 지금 여기서 이 진행하는 어떻게 진행된다는 걸 설명을 드렸는데요. 그 법적 권리, is this a legal right? I mean, what you have explained to him.
Yes, does he understand?
예, 그거 이해하셨나요? 예, 어떻게 진행된다는 거 다 지금 설명해 드렸습니다.
예, 알겠습니다.
Yes, I do.
All right, because this is first arrest, let's go straight to Ms. Bickerstaff.
Yes,
I'm
Your
sorry.
Honor. Yes, so this incident occurred yesterday at about 9 a.m. at 11595 Crossington Road in Johns Creek.
예, 지금 오늘 혐의로 들어온 이 사건이 어제 4월 25일 9시쯤, 아침 9시쯤 11595 크로싱턴 로드, 존스 크릭에서 발생했습니다.
This is where officers arrived in response to an argument with the defendant and his wife, Miss Melsuck on.
예, 이 사건 때문에 경관이 출동을 했고요. 이제 피고는 와이프 이름 모카 아닙니다.
The defendant slapped and kicked his wife, and officers noted visible injuries.
예, 미스터 안이 여기서 피고인인데요. 피고가 그 와이프를 쳤고, 그리고 경관이 친 곳에 이렇게 다친 거를 봤습니다.
I would like to sound for Miss An if she's on the Zoom call.
네, 미스 안이 여기, I'm sorry, I didn't get what you just said.
I would like to sound for her if she's on the call, if she would like to speak now.
예, 미스 안, 혹시 여기 지금 다 이 히어링에 청문회 들어와 있으면은 듣고 싶은데요. 여기 계신가요?
Ms. An, if you're present and would like to make a statement, this is your opportunity.
네, 미스 안, 혹시 듣고 계신지요? 여기서 하실 말씀이 있으신지요?
Ms. Bickerstaff, I'm sorry, what was the requested amount of bond?
Yeah, so the state's recommendation is a $3,000 surety bond, 1-day anger awareness course, no further contact with Mrs. An, a stay away order at the 11595 Crossington Road address in Johns Creek, as well as no alcohol, drugs, or weapons while out on bond.
예, 여기 주에서 권하는 거는 3,000불 보석금을 권하고요.
얼마요?
검찰청에서 3,000불이요. 그리고 하루 교육, anger awareness, 그러니까 화나는 이거 증오, 그거 이제 배우는 그 교육 하루 배우고, 그리고 이제 미스 안하고 더 접촉하시지 마시고요. 그 주소지에서 떨어져 계시라고 합니다.
예, 알겠습니다.
Okay, I understand.
All right, Ms. St. Flex, please proceed.
Yes, Judge. Mr. tells me that him and his wife has been together for over 30 years.
예, 미스터 안이 저한테 얘기한 바로는 부인하고 사신 지가 30년 넘게 같이 살았고요.
They have a daughter together that is 28 years old.
예, 그리고 딸이 하나 있는데 28세 된 딸이 있고요.
He completed high school and has been working at grocery store H Mart for the last 6 months, but previously to that, he had a job for 10 years.
예, 그리고 이제 학력은 고등학교를 졸업하셨고, 그리고 현재 일하는 그 H마트에서 6개월 지금 일하고 있고요. 그 전에 직장은 10년 일을 했습니다.
So he has significant ties to the community.
그래서 피고가 여기 지역사회하고 밀접한 관계를 갖고 살고 있고요.
He's been living in Georgia for over 20 years
그리고 조지아에 거주한 지 20년이 넘었습니다.
and also has a brother who lives here.
그리고 이제 brother, 형도 여기서 살고 있고요.
As the court heard, this is Mr. An's first arrest.
예, 이 법정에서 아시는 바와 같이 지금 현재 미스터 안이 이렇게 이제 체포된 거는 처음이고요.
And so him and his wife have not had previous incidents, according to my conversation with him, where there has been any threats or accusations of violence.
예, 제가 그 피고하고 얘기한 바에 따르면은 피고와 그 부인하고 사이에 무슨 이런 일이 전에 있었다든가 뭐 협박적으로나 뭐 윽박지르거나 이런 거는 전혀 없었습니다. 지금까지.
There is a language barrier, but we would be requesting that Mr. An is allowed to go home back to the address and there is no further violent contact based on his lack of history.
예, 그래서 저희가 저희가 원하는 것은 미스터 안이 주거지로 돌아가시고 그리고 전처럼 그런 폭력적인 그런 거 쓰지 마시고요.
Additionally, he doesn't have the contact numbers of his other family members, so he would have a very difficult time bonding out of jail.
추가적인 것은 지금 부인 외에 다른 뭐 형님이라든가 아는 분들의 전화번호를 아는 게 없어서
So
자기 보석금을 걸고 나가기가 좀 힘들 것 같습니다.
So we are requesting a signature bond in his case.
그래서 저희가 원하는 것은 시그니처 보석을 원합니다.
And we are requesting that the court not issue an anger awareness as we are unaware as to whether or not there would or would not be a Korean interpreter for him to be able to go through.
예, 그리고 저희가 주에 원하는 것은 지금 이거 화가 났을 때 받는 이 하루 무슨 교육 받으러 한 것도 빼주시고 그리고 또 만약에 또 보낸다면은 언어적으로 또 안 되기 때문에 통역자가 또 따라 붙어야 됩니다.
Nothing further.
예, 그 외에 더 드릴 말씀은 없습니다, 판사님.
All right. Defendant will receive a $3,000 signature bond through pretrial.
피고가 프리트라이얼 전에 먼저 했던 그 재판에서 3,000불 보석금을 받았나요?
He's to have no further contact with Miss An.
예, 그거 3,000불 보석금하고 미스 안하고 더 이상 접촉하지 말고요.
And he is to stay away from the incident location.
그리고 그 발생한 폭력이 발생한 그 주소지에서 가까이 가지 말고요.
He is further to have no alcohol, drugs, or weapons as a condition.
그리고 이제 음주라든가 무슨 뭐 무기라든가 이런 거를 소지할 수가 없습니다.
Is there anything further from either party?
Judge, I need to see if they can get an interpreter for orientation. I'm not sure.
Will you see?
Yeah, y'all got to hold though. It's gonna be a minute.
Okay.
Okay. What is this about the interpreter that you need to get for?
We're trying to determine whether his case can go through pretrial services and whether there will be someone there to interpret for him.
예, 지금 프리트라이얼이라는 거는 협상 과정인데요. 그거를 할 수 있으면은,
Other than issue,
통역자를 또 써야 된다고 하네요.
And Judge, we would just add that I think they have to meet with pretrial once a month. So he would have to have an interpreter for each time he goes. So we would just ask that the signature bond is through the jail.
signature bond will remain through pretrial pending that they can accept him.
예, 시그니처 번을 지금 변호사께서 계속 주쪽으로 그렇게 해달라고 지금 요청을 하고 있습니다.
예, 그렇게 하겠습니다.
Yes, yes.
Oh, and also he can return one time with law enforcement to get his items.
예, 그리고 이제 집으로 발생한 그 집으로 돌아가셔서 경관이 같이 가셔가지고 필요한 사적 물건은 가지고 나올 수가 있습니다.
예, 감사합니다.
Thank you.
All right, pending Mr. Howard's return. Is there anything further, Ms. Bickerstaff or Ms. St. Flex?
Nothing from the state.
Nothing further.
미스터 하워드가 아마 그 프리트라이얼 하는 것 때문에 지금 뭐 알아보러 가신 것 같아요. 근데 이제 그 외에 변호사 측이나 판사 쪽에서 더 검사 측에서 더 할 말이 이제 없는 걸로 됐습니다.
All right, Ms. Choi, if you would mind staying for one moment, we are going to go to another position temporarily until Mr. Howard returns.
Okay. May I ask you a question?
Yes.
What is signature bond?
Oh, signature bond means that he's going to be, he'll be able to sign his own bond and be released from the jail. So you might want to explain that to him.
네, 조금 아까 시그니처 번드로 해주신다고 했는데요. 저도 그걸 잘 몰라서 판사님한테 여쭤봤는데요. 시그니처 번드라는 거는 본인이 그냥 사인하시고 나가시는 거라고 합니다.
예, 알겠습니다. 나가가지고 나가서 저기 변호사를 선임해서 이번 일을 말끔하게 정리하겠습니다.
Yes, once I am released, I will have my own attorney and get this handled.
All right. So let's hold for one moment. Can we go to another position at courtroom 2 for a moment?
예, 잠깐 기다리십시오.
Position 9, Meunier.
All right, good afternoon, Mr. Meunier. Your case is 23 CR 002568G. In this case, you're charged with 2 counts of simple battery family violence. Do you understand your rights today?
Yes, ma'am.
All right, I'm going to defer to the state for the history until Mr. Howard returns. Mr. Young, please provide me with the history as well as your recommendation.
Your Honor, my understanding is that this defendant does not have any history. The state's recommendation is a $3,000 surety bond, no further contact with the victim, Khadijah Ahmed and Fatima Meunier. On yesterday at 5645 Sandown Way in Johns Creek, law enforcement responded to a disorderly juvenile call. Upon arrival, law enforcement spoke with Ms. Ahmed, who stated that her son, the accused, pushed her to the floor inside their home when she tried to wake him for an appointment. And his sister, the other victim, Ms. Meunier, stated that she witnessed her brother push the mother to the floor and hold her down. She stated that her brother pushed her when she tried to get him off her mother. There was also a 6-year-old juvenile who witnessed the incident as well. Our office has been in contact with the mother who wishes her son to come home because he is a junior in high school. However, the state is somewhat reluctant. I think that's all for the state.
All right, so the state is still requesting the no contact. Is that clear? Is that correct?
That's correct.
All right, is the victim, is she on the line? Is Ms. Ahmed present?
The mother is in here in the courtroom, Judge, in the gallery.
Okay, so if she could come forward and make a statement if she wishes to.
Yeah. Oh, yeah. Yeah, that's it.
Stand by.
Just stand right here.
Hey.
All right, will you please raise your right hand? Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. And as a question, is your daughter there as well?
His older sister came in when she heard the scuffle.
Oh, wait, no, don't tell me that yet. I was asking a question. Is she also there? Is his older sister there right now in the court with you? Did she come to court today too?
She's in school.
She's in school. Okay. I don't know if you've heard the other, you probably didn't, you were out in the gallery. I'm not sentencing him today. This is not a probable cause hearing, so the facts are not critically important. What's most important is whether you wish to have contact with the defendant, whether you have any fear of him. But of course, I will hear some statements from you. So please go ahead.
Yes, I do wish to have contact with him.
Okay. You can tell me, what else would you like to tell me at this time, Ms. Ahmed?
Basically what happened was, I was waking him up for an appointment. He came back from Kenya 2 weeks ago. He was complaining of some back pain, so I just wanted to get that checked out. He knew about the appointment when we made it, and I also wanted to get him enrolled in homeschooling so that he's just not sitting around at home. He refused to wake up for the appointment. He didn't want to do anything with homeschooling. And I was like, you can't sleep in your bedroom and be comfortable and not want to do anything with yourself. You have to go sleep out on the porch. He refused to go out on the porch. And I said, I'm going to stay in here. We kept arguing. And so he pushed me. He didn't punch me. He didn't slap me. He pushed me to the ground. And I yelled out, and my oldest daughter came in. She's like, what's going on? And she's like, oh, you need to go in the car and just go to your appointment and just get this day over with. It's not that big of a deal. And he pushed her to the ground. When my 6-year-old was done getting ready for school, brushing her teeth and things like that, she ended up coming. By that time, I'd called the police and they showed up. And I thought they were just gonna like de-escalate the situation and tell him to go out on the porch and cool off or whatever, or walk. And he was placed under arrest.
Okay. All right. Thank you for coming to court, Ms. Ahmed. I appreciate you making that statement at this time. Ms. St. Flex, please proceed.
Yes, Judge. As you heard, Mr. Ahmed is 17 years old. He's in the middle of homeschooling. Was supposed to be homeschooling. He told me that he had an interview yesterday at Panera Bread. I think it's clear from his mother's statement, she didn't expect the situation to go to what it has gone to with him being arrested and in jail, that she expected it to be a de-escalation situation. She hasn't stated that she's in fear of him and that she wants him to come home. And so we're asking, according to my conversation with him, he has no other family here. They moved here in 2021 from Michigan. So his stepdad also lives in the home with them. So this is the only family he has. And if he can't go back home, he's homeless. And so we would just ask that there's a no further violent contact stipulation put into his bond instead of a no further contact, so that he may return home and finish with homeschooling.
All right. At this time, defendant will receive a $5,000 signature bond through pretrial per judge. I'm sorry, was there 2 counts? It'll be $2,500 on each count. He is to complete 20 hours of community service and take the 1-day anger awareness course. And he's to have no further violent contact with either of the alleged victims in this case. Is there anything further?
What position is this?
This is position 1.
Oh, who's co-signing? He's 17. Who's
His
co-signing?
mom is there at the jail. I know the victim is not supposed to co-sign, but in light of the no further violent contact, does he have a father who could co-sign, Ms. St. Flex?
He told me that his stepfather lives there. I don't know if he's at work or what his schedule is, but he did tell me he has a stepfather.
Let's make the stepfather the co-signer. That was just better in this case. What is the
Judge,
stepfather?
this is position number 9.
I'm sorry. You're right. It's 9, Miss Bridgewater. I apologize.
Okay.
1 is the one that's still pending. I'm sorry. Go ahead, Miss St. Flex.
Yes, Your Honor. I don't know what his, like I said, I just don't know what his schedule is, but he does tell me his stepfather lives here. That's correct, Mr. Ahmed, right? Your stepfather does live here?
Yes, ma'am.
Okay.
What's his name?
Mustafa, Mustafa.
All right. Last name.
Mayani, Mayannr.
All right. All right. Did you get that, Mr. Howard? And I will
No.
waive utility. No, you did not.
I didn't either. It was very faint. Can someone put it in the chat?
Could you say it louder, Mr. Ahmed?
Speak up.
His name Mustafa, Mustafa. Last name Mayani, Mayanr.
And this is stepfather or father?
Yes, he stepfather, but he really don't.
Stepfather.
He really.
All right.
Okay. Is there anything further as it pertains to this position?
How much was
Nothing
that bond?
further.
5,000 SOB.
And you said 20 hours of community service?
Yep. Okay. Anything further?
Nothing further.
All right, let's go back to position 1, the one that I thought I was gonna. Because of the challenges that I've been made aware of. Ms. Choey, are you still here?
Yes, I am.
All right, please interpret this for me.
Okay.
Because of the challenges that I've recently been made aware of in monitoring the defendant, his signature bond will go through the jail at this time.
I'm sorry. What does that mean? Signature bond will go through the jail.
He will receive a signature bond that he will sign himself. He will not be monitored by pretrial services because the resources are just not there to monitor him.
Okay. 예, 지금 시그니처 그 번드로 그거 하는 거요. 그거 이제 하시고 이제 나가시게 되는데 프리트라이얼 그 뭐 모니터링 그러니까 이렇게 계속 주셔야 하고 이제 뭐 이렇게 누가 나와서 보고 그래야 되나 봐요. 그거를 할 사람이 없다고 그러네요. So does this mean that he can still sign himself out?
Yes.
예, 그렇지만 사인하고 가실 수는 있다고 합니다.
And please, Mr. An, please keep your address current with the court so you receive all court notices.
예, 그리고 Mr. An 어디에 계시든지 콜트에다가 그 주소를 계신데 콜트에서 보내는 주소 이 우편을 받을 수 있도록 왜냐하면 법정 날짜가 정해질 거예요. 그거를 받을 수 있도록 그거를 알려주셔야 됩니다.
예, 나가서 저기 변호사를 선임해가지고 다 서류를 마련해서 보내겠습니다.
Yes, I do plan on hiring an attorney, so I will get my address and all that.
All right. I believe that concludes position 1. Is there anything further from either party?
Nothing further.
예, Mr. An 이거로서 종결하는데요. 뭐 더 하실 말씀 있으신가요?
없습니다. 도와주셔서 감사합니다.
Nothing further. Thank you for your assistance.
All right. Best of luck to you, Mr. An. And Ms. Choey, I believe that concludes your business. You can be excused.
예, 그러면 Mr. An 지금 종결됐고요. 저도 그러면 이만 나가겠습니다.
감사합니다.
네, thank you. Thank
All
you.
right. Have a good day.
Thank
All right.
you.
Who do we have next?
Position 5, Das.
All right. Good afternoon. Your case is 23 CR 0025558J. In this case, you're charged with simple battery family violence. Do you understand your rights?
Yes, ma'am.
All right, thank you. Let me see, let me look at my sheet. Oh, first arrest, so we will go to Ms. Bickerstaff.
Yes, Your Honor. So this incident occurred yesterday at about 7:50 in the afternoon, where officers arrived at 8:30 Chatburn Lane in Johns Creek. And this is where officers arrived in response to a domestic dispute between the defendant and his wife, Miss Pompey Dawes. Pompey is spelled Pompee, where the defendant slapped her in the face several times, Your Honor. Our victim advocate was able to speak to Ms. Dawes today, and she let us know that they are married, that the defendant and her are married with children. And she stated that she needs the defendant to come back home and to help her take care of their children. The victim's Ms. Dawes stated that things have been stressful around the home and that she recently went to the doctor and she was advised to go to counseling, Your Honor. The Ms. Dawes did let us know that she would like contact with the defendant. However, the state wants to make sure there has been an adequate cooling off period between them, and because this incident did occur yesterday evening. For these reasons, the state's recommendation is a $3,000 surety bond, a one-day anger awareness course, no further contact with Mrs. Dawes, and to stay away from that 830 Chatburn Lane in Johns Creek, as well as no alcohol, drugs, or weapons while on bond. And I would like to sound for Ms. Dawes if she is on the Zoom call.
All right,
Yes, I'm there.
All right, please, Ms. Dawes, if you'd like to make a statement, please raise your right hand.
Yes.
Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and
Yes,
under the
Your
penalty of perjury?
Yes, Honor.
All right, you can put your hand down. Again, as you've heard me explain, the facts of this case aren't as critical as whether you wish to have contact with the defendant, whether you have any fear of him. But I will hear a statement from you. What would you like to make me aware of?
So I already gave my statement to the officers yesterday and also today morning when I got the call from Miss Kelly, what had happened. So that's all. But I would like to clarify. I may understand it incorrectly, but I did not want to completely cut off the contact with him because we have 2 kids, with including a 9-year-old special needs child. So definitely, if we have to decide how we are going to handle things for future, we have to be in contact. So definitely, he can come back home, and we can talk and try to figure out what will be the next point of action, or
All right.
we can do.
Thank you. I appreciate you coming to court and making that statement. Ms. St. Flex?
Yes, Your Honor. I spoke with Ms. Dawes this morning, and she told me that they've been married for more than 11 years, and she has never had an incident similar to yesterday between her and her husband. She said she's never seen him angry to the extent to where she felt like she needed to call the police, and she felt like this was an isolated incident. We are asking because of what she stated, which is also something that Mr. Dawes informed me about. Their special needs child that has been diagnosed is a child that has to be cared for by both of them. They both have been caring for the child because they both work full-time jobs. And so neither parent is really able to care for the child alone, in addition to the 2-year-old that they have. The special needs child is 9 years old. And Mr. Dawes, as you've heard from his history, has not had any prior incidents similar to this. This is his first arrest. He's been working at the company that he's working at for over 10 years. He has a master's in computer application. He's in IT. And so we're asking, and he's been living in Georgia for more than 5 years, so he has ties to the community. We're asking that the court just grant the wish of the wife in this case. I know the prosecution said they want a cooling off period, but Mrs. Dawes has the right, which she's done previously yesterday, to call the police if there's any issue. So she can call the police with a no further violent contact. And with these 2023 cases, you know, it may be a while, it may be a year, 2 or 3 years before his case is resolved. And so, there's no specific amount of time waiting on his case to be resolved that a cooling period would be sufficient for, based on his no criminal history and his circumstance with his wife. So we're asking for a signature bond in his case, Your Honor, and we're asking that he's allowed to return to the home with a no further violent contact order.
All right. At this time, defendant will receive a $5,000 signature bond through pretrial per judge. He's to take the 1-day anger awareness course and have no further violent contact with alleged victim. Additionally, he must have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further, Your Honor.
All right. Best of luck to you both. Who do we have next?
Thank you so much.
Position 6,
Can I drop, Your Honor?
Frampton, come on. My bad.
I'm sorry, I didn't hear what position.
Position 6, Frampton.
Okay, Mr. Frampton, your case is 23 CR 002559H, and you're charged with obstruction with the offense date of April the 25th. You understand your rights?
Yes, ma'am.
All right, Mr. Howard, will you put the history onto the record for me?
2023 DUI, 2018 breaking and entering conviction, 2018 theft by receiving conviction, and 2019 damage to vehicle that was dismissed. That's it.
All right, thank you. I appreciate that, Ms. Bickerstaff.
Yes, Your Honor. So this incident occurred yesterday at about 7 p.m. at 142 Old Holcomb Bridge Road in Roswell, Georgia. And this is where Officer Brasco gave the defendant verbal commands to stop and come to him multiple times, but the defendant refused and continued to walk away. And then when another officer, Officer McDonald, commanded the defendant to get on the ground, the defendant, he did do it. He did obey verbal commands that time. But for these reasons, the state's recommendation is a $3,000 assured signature bond through pretrial services. And that's all from the state.
All right, Ms. Wills.
Thank you, Your Honor. I do not have any objection to a signature bond for Mr. Frampton.
All right. Defendant, I'm sorry, there was no stay away location, was there, Ms. Bickerstaff?
No, there's no stay away location.
Okay. Defendant will receive a $3,000 SLB through the jail. Additionally, he needs to have no drugs, alcohol, or weapons as a condition. Is there anything further?
Nothing from the state.
Okay. Best of luck to you, Mr. Frampton. That concludes your case. Who do we have next?
What was that breakdown?
I'm sorry, there was there was only one charge.
Only one.
Oh, okay. So that was 3,000?
Yes.
All right, thank you. Do you mind her return? Yeah, thank you, Your Honor.
All right. Best of luck to you. Who do we have next?
Position 15, Mr. Walker.
All right. Good afternoon, Mr. Walker. Your case number is let's see, 23.
my bad.
Oh, it's not?
Position 2.
Hey, stop laughing, it's not funny, it's the law.
Okay,
Position
we're doing 2.
Yes.
I requested a breakout room for position 2 as well as Mr. Patterson. I'm not sure what position that is.
Okay, can we take the breakouts at the end so we can kind of do them all at once if possible?
Hey, thanks.
Is there another position we can do?
Position 7, Jenkins. Jenkins.
All right. All right, good afternoon, Mr. Jenkins. Your case is 23 CR 002560A. In this case, you're charged with theft by shoplifting with the offense date of February the 22nd. Do you understand your rights?
Yeah.
All right, Mr. Howard, will you put the history on the record for me?
7 total. He got an open pretrial case for shoplifting and obstruction, possession of a controlled substance. Open case for burglary first degree and burglary in the second degree out of the cab. 2021 theft by deception conviction. 2021 theft by receiving conviction. That's it.
Okay. Thank you. All right, Ms. Bickerstaff?
Yes, Your Honor. So this incident occurred February 22nd, 2023, around 4 p.m. at 3719 Old Alabama Road, which is the Grapes and Grains store. And this is where officers arrived at Grapes and Grinds and spoke with the manager, Ms. Jennifer Peters, Ms. Jennifer Peters, about a shoplifting. Surveillance video captured the defendant concealing 3 bottles of tequila in his jacket. The defendant took 2 bottles of Casa Azul and a bottle of Casamigos, all totaling to $448.96. Your Honor, the defendant does have an open case. That case number is 23 CP 216629 for possession of controlled substance and theft by shoplifting, but this theft by shoplifting case was at a package store. The defendant also has 2 other open shoplifting cases, Your Honor. And for these reasons, the state's recommendation is a $2,000 surety bond and to stay away from Grapes and Grains store, which is 3719 Old Alabama Road, and as well as no alcohol, drugs, or weapons while out on bond.
All right, thank you. Ms. Wells?
Thank you, Judge. My client is 24 years old. This incident did occur back in February. He reports that he is employed. He works for Anytime Transport with his father as a truck driver and has been doing so for the past 3 years. He also further reports that he has a child on the way. And speaking with Mr. Jenkins, he did state that he will not be returning to that store, so we have no objection to no return. I would request a signature bond in this case. If Your Honor is not so inclined, I would ask for a low bond. Thank you.
All right, defendant will receive $1,000 surety bond. He's to stay away from the incident location on Old Alabama and have no alcohol, drugs, or weapons. Is there anything further?
Nothing from the state.
All right. Best of luck. Who do we have next?
Position 15, Walker.
All right.
Who's Walker? Walker, come on, pull your pants up, all the way up for me.
Okay. Mr. Walker, your case is 23 CR 002567Y. You're charged with abandonment of a dependent child with the offense date of March the 29th. You understand your rights?
Yes.
All right. Mr. Howard?
Just, I don't recall seeing any arrests related to abandonment.
Okay. All right, thank you. Mr. Young, please proceed.
Yes, Your Honor. In this case, against Mr. Walker, the offense happened March 29th, 2023. There's a purge amount in this case for $380. Mr. Walker apparently left a minor child alone. And that's all from the state.
All right, Ms. St. Flex?
Yes, Judge, Mr. Walker, currently, like the prosecution stated, has a $380 purge amount on this case. I did speak to him about his affordability of that purge amount. He did inform me that he's not able to afford that amount. And so, you know, really there's just an inability to pay on his behalf and a lack of resources. So we're asking that he's able at minimum to bond out on half of that purge amount, which would be 140. I think I did the math right. 140 on that. And then a condition of his bond would be to pay the other half upon release, within a certain time upon release, since he's not able to afford the entire amount to get out.
I think that amount is 190.
I was about to say, I don't think I'm bad at math, but
Okay, I did not do engineering for a reason, but yes.
Okay. How would we monitor the balance if he's allowed to divide it That would be my
Baby,
only.
talking about this baby, I don't even know where my fucking baby at, bro.
Okay, please mute it, Kirtland, too. Please
I don't
mute.
even know where this man.
Please mute him. Thank you. If we were to allow him to apportion the purge amount, there's really no way to do that, to my understanding. How are we manage? I don't think we can do that. I think the purge amount would have to stand, Ms. St. Flex.
Okay, Judge.
That's my understanding of how this works. Mr. Young, would you like to weigh in?
Also, I was looking, it sees that, looks like Mr. Walker's been held on 16 charges. So even whenever he pays this purge amount, I don't think he'll be making bond anytime soon.
Okay. 1 second, Mr. Walker, please don't say anything that can be used against you. All right, I believe
my baby, y'all.
Okay. All right. So at this time, I believe he's going to have the $380 cash only purge amount bond. And he's additionally to have no drugs, alcohol, or weapons as a condition, should he make that bond.
Thank you, Your Honor.
All right, Mr. Walker, the best thing for you to do is to speak to your attorney. I don't want you to say something that gets used against you by mistake, okay?
And there will be an attorney, Your Honor, that will visit him before his next court date.
All right, and exactly. So an attorney is coming to see you, okay? All right. Best of luck to you, Mr. Walker.
Position 8, Jones.
Yeah.
All right. Good afternoon, Mr. Jones. Your case is 23 CR 002561Y. You're charged with simple battery family violence with the offense date of December the 19th. You understand your rights?
Yes, ma'am.
All right. Let's see. Mr. Howard, will you put the history onto the record for me?
7 total. Let me ask a question. What's the victim name in this case? State, can you answer that for me, please?
I have Marquette Hunt.
Did you see a TPO? Did you see a TPO?
Yes.
Yeah, I forgot to copy and paste it. I'm sorry, but okay, we'll get to it. Judge's 7th arrest. He got history out of Alabama. Open family violence, DV 3rd degree. Let's see, a family violence 2nd degree, criminal trespass 3rd degree, domestic violence 2nd. That's traffic. 2019 driving case, 2019 domestic violence that was dismissed. Like I said, another 2019 domestic offense, 2016 DV failed to appear, 2014 trespass and DV. Most of that history is Alabama, Judge.
Okay, that's sufficient.
Yeah, I think I did see a TPO. State can probably.
Right. And I see the alleged victim in this case on the line. All right. So, Mr. Young, please proceed.
Yes, Your Honor. On 12/19/2022. Okay, right. Law enforcement responded to 283 Sunset Avenue Northwest in response to a domestic disturbance. Ms. Hunt stated the officers didn't speak to her until the following day, December 20th, when she advised law enforcement that there was a verbal altercation. When the accused walked out the residence, they shared together. She attempted to lock him out. Fortunately, the accused stopped her, grabbed her by the hair, and drug her to the bed. He then raised his fist as if he was going to strike her, but didn't. We have had some contact with the victim. She advised that she is working on her relationship with the accused, and they share a child together. This is the first time that something like this has happened between the two. However, I know there is a TPO, temporary protection order, and the state does have some concerns about reoffending and tied to the community, given the fact that the defendant is a multi-state offender and he has a history of domestic violence. The state's recommendation is a $4,000 surety bond, no further contact with Ms. Hunt, stay away from the incident location, 1-day anger awareness, no alcohol, drugs, or weapons. My understanding that the victim wants to lift the TPO. She's supposed to be working on that. However, the state is concerned because there's a TPO. He violated it by going around her and committing this crime. That's all from the state.
All right. Now, Ms. Hunt, please raise your right hand. Then you need to unmute your screen. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, I do.
All right, the court will hear from you and allow you to make a statement. Do you have a valid TPO at this time?
Yes, I got it after that incident. He didn't violate anything, and that didn't happen that way. The incident happened, and then I got the temporary order just because I was pregnant at the time. And now that I've had my baby, we've had a much better co-parenting experience with the help of my mom. So we've done much better with communicating. I think there was just a high stress time with the holidays, and I was close to delivery that the incident ended up occurring. But I am dismissing or lifting the temporary order. I was supposed to do that last week, but I had my baby.
Okay, thank you. I appreciate you coming to court and making that statement. Ms. Wills?
Thank you, Judge. My client is 32 years old. As it was stated, this incident occurred back in December, so there has been an adequate cooling off period. My client reports that he has been in Georgia for the past year, and he does have family here. He is the father of an 8-year-old, a 9-year-old, and a 4-month-old. He has several jobs. He works for the Army National Guard. He works as a security guard for ADT, as well as part-time in Costco's warehouse. As it was stated by the alleged victim in this case, she does desire to have contact and communication. There have not been any other further events or incidents since what happened and occurred in December. And in speaking with Ms. Hunt, she said no situation had transpired like that prior to December also. And so I would request that there be a no further violent contact. I understand that there is currently a TPO in place. So of course, I would ask that my client abide by any active TPOs, but if it's lowered, no violent contact between him and the victim. And I also would be requesting a signature bond. If your honor is not so inclined, I would ask for a $1,000 surety bond.
All right, defendant will receive a $4,000 surety bond. He is to abide by the terms of the TPO and have no contact with alleged victim and stay away from the incident location. Should the TPO be modified, he is to have no further violent contact with her. Additionally, he's to have no drugs, alcohol, or weapons as a condition of that surety bond, and he will be reset to state off purpose on May the 9th. Is there anything further?
No, your honor.
All right, best of luck to you, sir. That concludes your case at this time. Are the remaining cases all breakout cases?
Position 11, Patterson.
Patterson is not a breakout case?
It is.
It is. I should have one client, Mr. O'Brien, and he's not breakout.
And then Mr. Patterson, I have a waiver for him.
And then I also have position 12, Peoples. I'm not sure if that's a breakout as well.
That is not a breakout.
Okay, so we can do that one.
Come on, position 12, Peoples, come on.
All right, Mr. Peoples, your case is 23 CR 002564F. You're charged with loitering and prowling with the offense date of April the 24th. You understand your rights?
Yes, ma'am.
All right, this is that co-defendant case, correct? All right, Mr. Howard, can I have the history, please?
49 total. 2022 shoplifting conviction. 2019 FTA, possession of drug-related objects, possession of a controlled substance conviction. 2019 probation violation, fugitive arrest. 2018 failure to appear, shoplifting conviction. Well, 2 shoplifting convictions and 2 FTAs. That's all I put.
All right, Mr. Young. And again, is this a co-defendant case? I believe I know the facts.
Yes, this is the co-defendant case.
All right, please proceed.
The state's recommendation on this case is a $3,000 surety bond, stay away from the incident location, no further contact with the victim, and no alcohol, drugs, or weapon while out on bond.
Okay, thank you. And Ms. Daniels, we've heard from you on the last case. Do you wish to make a statement as it pertains to this case? All right, assuming no. Ms. Wills?
Thank you, Judge. Mr. Peoples is 36 years old. He stated that He states that he has lived in Georgia all of his life. He does not have any children. He reports that he is employed by Reshore Reliable Moving Company. And he denies the allegations as alleged. He states that he was at the location with his girlfriend, Miss Rutledge, and she was looking for relatives. She states that they lived in that apartment complex. She just didn't know exactly what apartment number that they stayed in. So I would request a signature on bond in this case. And if your honor is not so inclined, I would ask for a $750 surety bond.
All right. At this time, defendant will receive a $1,500 surety bond. He's to have no contact with the alleged victim whatsoever, stay 100 yards away from the incident location, and have no alcohol, drugs, or weapons. Is there anything further? All right, best of luck to you, Mr. Peoples. That concludes your case. And if I could be placed in that breakout room now with Ms. Wills, Ms. St. Flex.
I still have Mr. O'Brien, Judge, who is not breakout.
Okay. So can we do that position? Mr. Peoples, you're raising your hand. The best thing for you to do is speak to your attorney about this. Yes, Mr. Peoples, what is your question?
Of course, I just like, well, I seen the case where Miss Rutledge was on. They said that she said she found out she's pregnant. Now that just hit me, and like it's nothing I could do with it. I need to be there for her. Like a signature bond will help me. I can't do nothing. I can't right now. I can't. There's no other way I could bond out. If you could please put it on your heart to give me a signature bond.
Okay, the ruling will stand at this time, but your case will be revisited on May 9th if you're unable to make bond, okay? All right. Can we take Mr. O'Brien?
That's not the last case, Judge. We also have position 11, Patterson.
And that one's not a breakout?
No.
That is a breakout.
That's a breakout requested for that.
And I'm waiving his appearance as well. And I sent that over.
Okay, so we'll take it back.
And I also have it, Ms. Wills.
Thank you.
You're welcome.
So who's next?
We're waiting for O'Brien or any of them.
O'Brien.
I believe it's the last case that's not waived. I mean, not breakout.
This is position 10, Mr. O'Brien.
All right, Mr. O'Brien, your case is 23 CR 002563C. You're charged with making harassing communications with the offense date of November of 2020. Do you understand your rights?
Yes.
All right. Mr. Howard, can I have the history, please?
This is 10th arrest. His history consists of DUIs and license issues, whether they suspended or driving without a valid license. That's the whole history that I saw.
Okay. Mr. Young?
Yes, Your Honor. This incident occurred back in November 2020, where the accused began contacting the victim, Ms. Angela Evans, also would ask court to sound for her when appropriate. The accused began sending her emails from a Yahoo email address, continuing until December of 2020. He created the email address pretending to be another person and began accusing Ms. Evans of intimate contact with another man. The accused also threatened Ms. Evans, saying that he would pull her, I'm quoting, horse teeth out one by one and by throwing acid in her face.
I'm sorry. If Mr. Young, if you're gonna mention something that's in the accusation that has anything to do with the child, then I'm gonna ask us to just finish this in a breakout. I just don't want this to be lively recorded because I think I know where the rest of the warrant is headed.
Okay. So let's All right. So, Mr. Young, do you feel that you can do that without making those statements, or is a breakout required for this as well? I think I understand the flavor of what's happening here, though.
Yeah. Okay. If you, I can avoid that portion in the accusation, so you can see it. He also sent her emails to intimidate her by saying that she's being watched and described her day-to-day activities as her place of employment. And she also told the victim that she would be accused of illegal drug use to get her fired. He sent more than 50 messages, and that one fact I'm leaving out in relation to the child. State's recommendation. I see that there's currently a $1,000 surety bond. The state will request no further contact with Angela Evans and to stay away from any place that she might be. The location listed in the accusation was 7300 North Point Parkway. I believe that's a business. That's all from the state.
Is Ms. Evans present? Okay. Hearing and seeing none, Ms. St. Flex?
Yes, Judge. As you heard, this case took place in 2020 through 2021. It's alleged to have taken place in 2020 through 2021. When I spoke with Mr. O'Brien, he stated it was his understanding that this case was resolved in Augusta County. He recalls going to court in Augusta County, and I'm sorry, Augusta in Richmond County, and doing a no contact provision with the alleged victim in this case at the end of year 2020. And that was the last form of contact that they have had. So since that time, obviously, I think it's safe to say there's been no contact because we're here not on any new allegations for harassing communications, but we're here on 2020 case. And I spoke to Mr. O'Brien about the bond and whether he would be able to afford to bond out on the bond amount that's currently set of the 1,000. He told me that he's unable to do that. He is a veteran. He was in the Army. He's been homeless for an extended period of time, but he just got an apartment through the Veterans Program in Monroe, Georgia, where he would be living. And through that program, he was also set up with a production supervisor position that's supposed to start today. I think at 2 o'clock it was supposed to start. And so he's really just now getting back on his feet. He has no family that lives here. It's just him. And so no one is able to come and, bond him out. He does have a daughter and 2 grandchildren who don't live here. And so we're asking, based on the age of the case, based on Mr. O'Brien not having any prior violent history, I think his years dated back history all go to driving charges. And based on the oldness of the fact that there has been no allegations of current or within the last 3 years of contact or communication, and his inability to pay for his bond at $1,000, that he is granted a signature bond in this case, and he's allowed to just return to court to resolve this at a later manner. He did tell me he had an attorney at the time, and so he's planning on contacting that attorney because he thought the case was resolved.
All right. Defendant will receive a $3,000 signature bond through the jail. He's to have absolutely no contact with Ms. Evans, stay away from the incident location and wherever she may reside or be or work. Additionally, he's to have no drugs, alcohol, or weapons. Is there anything further?
Nothing further, Your Honor.
Nothing from the state.
All right, best of luck to you, sir. All right, if we could go into the breakout room for the remaining cases, is that correct?
That's correct, Your Honor.
Also,
right.
quick judge, quick announcement for position 11, Mr. Patterson, and I am aware that he is a breakout case, but he refused to waive his appearance.
He refused to waive even though we have the waiver?
He doesn't want to waive his appearance, he said. He wants.
So he wants to be here. Okay. All right. So I guess we'll take him first, but let's still go into the breakout room. All right. At this time, we're first going to take up the case of Miss Simmons. Miss Simmons, Mr. Howard, can you put her history onto the record, please?
How you know I was back? Third arrest, 2020. She was put on probation, Hall County. Possession of a Schedule II controlled substance and obstruction. 2020 criminal attempt to commit a felony. 2 counts that was dismissed. That's it.
Okay. All right, Miss Simmons, I just want to make sure that you're aware of your case. I know it's been some time. In this case, you're charged with criminal trespass, 23 CR 002566D, with the offense date of February the 24th of 2022. Do you understand your rights today?
Yes, ma'am.
Okay. We've heard the history, Mr. Young. I'm aware of the facts. If you would summarize them briefly.
In February 24, 2022, the accused went to the incident location, being Your Pizza Pie restaurant, after being advised not to previously from being fired from the location. The accused was seen on camera turning over chairs. State's recommendation is to go with the $2,500 surety bond, stay away from the incident location, and no further contact with Christopher Foster, no alcohol, drugs, weapon while on bond.
Is Mr. Foster present? All right, hearing and seeing none. Ms. St. Flex, if you'd like to briefly respond.
Yes, Your Honor, we would just ask, based on her very limited history and the things we mentioned in the breakout, that she's allowed to have a signature bond, as this case did happen in 2022. And she is currently working at Walmart in Conyers, and not sure if she still has a job if she has to remain in jail.
All right. Defendant will receive $1,000 surety bond. She's to have no contact with alleged victim and stay away from that incident location, and additionally have no alcohol, drugs, or weapons as a condition. Anything further?
Nothing further.
All right, let's take the case. Mr. Patterson, best of luck to you, Ms. Simmons. That concludes your case. Mr. Patterson, your case, let's see. Let me give you your case number. Your case is 23 CR 002562F. You're charged with simple battery in this case. Do you understand your rights? All right, Mr. Howard, can you put that history onto the record?
Patterson, 43 total. 2010 assault conviction, 2015 trespass, 2015 burglary, second degree conviction, 2013 probation, trespass, shoplifting conviction, and 05 ag assault conviction.
All right. Mr. Young, if you briefly give us the facts, even though the court is aware, just very briefly, without reference to anything sensitive.
Okay. April 25th, 2023, at the O'Hearn house located 16 William H. Borders, the accused allegedly pushed and threw food into the victim's face while present at this location. There is surveillance footage of the altercation.
All right. Ms. Wills.
Thank you, Judge. My client is 56 years old, and without delving too deep into what was discussed in the breakout room, I have made efforts to contact and speak with Mr. Patterson's case manager at O'Hearn. I would request $1,000 surety bond in this case.
All right, thank you. At this time, defendant will receive a $2,000 surety. He's to have no contact with alleged victim unless, as we discussed in the breakout, is necessary, and stay away from the incident location unless the conditions apply as discussed in breakout. He is to have no alcohol, drugs, or weapons, and he is to undergo evaluations as discussed in breakout. Is there anything further? All right, Mr. Patterson, best of luck to you. That concludes your case.
All right. Excuse me, Judge. I thought we had said a 3,000.
I'm gonna change it to 2.
Okay.
But you're right, Ms. Bridgewater. That was what it was.
Okay.
All right.
This is position 2 camps.
All right. Thank you. Good afternoon, Mr. Camps. Your case is let me get back to it. I apologize. 23 CR 002555Y. You're charged with criminal trespass with the offense date of April the 25th. Do you understand your rights?
Yeah.
All right, Mr. Howard, will you put that history onto the record?
7 total. The open loitering prowling out of state court. 23 CR 001 390Y. Open marijuana possession and drug related objects.
All right, that's good. Ms. Bickerstaff, very briefly, if you just give us a short summation as the court is aware of the facts of this case.
Yes, Your Honor. So this incident occurred yesterday at 6 p.m. at the Sorrell Properties. That's 2399 Parkland Drive, Northeast, Unit 1020. And this is where officers arrived to the location in response to the property manager, Ms. Keisha Murphy, advising them that 2 men, one identified as the defendant, were in the apartment unit 1020 without authority, Your Honor. When police arrived, they did observe the defendant and one other person in that unit. For these reasons, the state's recommendation is a $1,000 surety bond, MHET, a stay away order from the Sorrell property at that 2399 Parkland Drive address, as well as no alcohol, drugs, or weapons while out on bond.
All right. Ms. Wells, a brief response.
Thank you, Your Honor. My client is 27 years old. He denies the allegations as alleged and reports that he is self-employed. I would like the court to take in consideration what was discussed in the breakout room, and we are in agreement with the $1,000 surety bond and the stay away order. Thank you.
All right, the state's recommendation will be accepted. It'll be $1,000 surety, and he must stay away from the incident location, undergo evaluations, and have no alcohol, drugs, or weapons. Is there anything further? All right, hearing and seeing none, that concludes the entire calendar. Courtroom 2 and 3 can be excused. Ms. Bridgewater, will you please review the calendar for me?
Yes, I will. Okay, once again, the reset date for the SAP calendar is May the 9th. Position number 1 is being reset further notice with a $3,000 SOB through the jail. Position 2 is going to the SAP calendar with a $1,000 good bond. Position 3 is going to the SAP calendar with a total $2,000 good bond. Position 4 is reset to the SAP calendar with a $1,500 good bond. Position 5 reset further notice with a $5,000 SOB through pretrial per judge. Position 6 is being reset further notice with a $3,000 SOB through the jail. Position 7, SAP calendar with a $1,000 good bond. Position 8, reset SAP calendar with a $4,000 good bond. Position 9 is being reset further notice with a total $5,000 SOB through pretrial per judge. Position 10, reset further notice with a $3,000 SOB through the jail. Position 11 is going to the SAP calendar with a $2,000 good bond. Position 12, SAP calendar, $1,500 good bond. Position 13, reset further notice with a $6,000 SOB through the jail. Position 14, SAP calendar with a $1,000 good bond. And on position 15, there is a $380 purge. Are there any questions, comments, or otherwise? No? Okay.
All right, we'll be in recess until tomorrow's SCA calendar, at which time I will be presiding. So see you all tomorrow afternoon. Take care.
Okay. Bye-bye.
Bye-bye.
Afternoon.